Cause us a nuisance. Good morning. My name's Bud Schneebly. All of you have my card appended to the materials. Feel free, if you wish to have any further dialogue, to send me an email or go ahead and call with any questions you may have. I've been practicing now, starting my 34th year, last 9 years with John. I've been doing legal malpractice for probably 25 of those years. At first started off doing the medical malpractice work, which, as we all know, with tort reform is not the same. But really, a medical malpractice case is very similar to a legal malpractice case. We're both dealing with a professional tort where somebody did something wrong or failed to do something. So when we first look at a legal malpractice action, and certainly from what I'm hoping I'll impart to you today, is your ability to go ahead and put preventative steps into place to prevent anybody from making a claim against you. It is simply a tort. You can have a contract claim if you have an employment contract. Most of the law says when a lawyer violates the standards of care, it's negligence. Very rare do you have a contract claim independent of a tort claim unless there's an employment contract that calls for you to do something that would have been outside the scope of an ordinary duty of care. So what is that tort? It's negligence. It is the omission by failing to do something, or commission by doing something overtly that is against the standards of the practice of law. And what that standard is obviously relative to expert testimony in the community. Pretty much the United States has been we all practice law the same, whether there's a state indifference or not, much like the medical field. However, obviously, each state has different nuances in the law, but it is what any reasonable and prudent attorney would have done. You're not held to an impeccable standard, but also if you take the money and you don't do anything, you're going to be liable for that, as you will see in some of the cases that I point out to you later today. But it isn't just enough to be able to do something wrong or fail to do something. That has to lead to damages. And oftentimes when I'm in front of juries, I'll draw a diagram of two canyons, a simple drawing, and I'll make a bridge between the two to explain to them that I have to connect the left side of the bridge to the right side of the bridge. That nexus must be there. If I can't directly and proximately prove that there are damages, the case will fail. And so it's my job to be able to point out the elements of a legal malpractice case to that jury and tell them once, tell them twice, tell them 3 times. Normally, you will not have any argument on the first 2 elements. Those elements are the attorney-client relationship. Very rare that you're going to have a dispute over whether or not there's an attorney-client relationship, but that's the first step towards finding a legal malpractice action. One of the cases here we'll talk about that is rather odd how the establishment of that relationship occurred, but it's often, I tell people it's often mirrored and when we go out to cocktail parties, and I know you've all had it, you're all lawyers, where somebody will pull you aside and say, hey, I got a question. Now, your initial response, whether it be truthful or not, doesn't matter because that individual is going to rely upon it, period. Whether or not you're retained, whether or not you have a signed engagement, whether or not you're paid. The fact of the matter is, once you impart a legal opinion and that person relies upon it, you have established an attorney-client relationship. The next element is and most of us, and what I do, is I detail an opening letter. Clients seem to think, and I've learned this over the years to refine this, clients seem to think you're their lawyer for everything, when they may hire you for only a limited scope of engagement. For example, if a client comes in to me and says, I want to sue Jane, John Doe. And of course, after a conflict check, I go ahead and tell them I can represent them. And then we meet to be able to further illuminate what the issues are. But then I'll write them a letter. The rules of professional conduct do not require you to have an engagement letter. They suggest you do it in writing. I'm telling you, I think it's, in my opinion, I've even had lawyers testify it's a standard of care. I've had both sides. I do not personally believe it's a standard of care because the rules don't mandate you to do it. But it's an extremely good practice because now you're defining the scope of your representation. And in other words, if somebody's saying you did something wrong, well, is it within that field of that scope of representation? For example, I will go ahead and have a legal malpractice action investigated and prosecuted on behalf of Jane Doe. Not John Doe, Jane Doe. If it illuminates into where there may be a co-defendant, whole new ballgame. Then you obviously inform the client of the changing circumstances and then enter into a new relationship. Obviously, probably a new fee agreement as well. Most of the legal malpractice cases are on fee agreements. You know, it's not only in the rules of, I think it's 1.5 if I remember correctly, or maybe 1.115, but it's statutory as well. Any contingency fee agreement you have has to be in writing, has to be signed. The rules do allow for referral fees, and I often do this. If other lawyers send me a case, I automatically will give a 25% fee back to them if they wish to accept it. However, they have to sign on the fee contract too. And it has to be disclosed to the client that you're giving them this fee. It's not 25% more, it's 25% of whatever fee that I would get out of it and negotiate with the client. By the way, that's becoming a liquid thing too. It used to be a standard third. Clients are getting smart out there now. They're not just shopping lawyers. They realize that they can negotiate for the higher value claims to have less of a percentage. So if you see that, don't be surprised. I'm seeing it a lot. Irrespective, you come back then to the attorney-client relationship, you have an engagement, you have it in writing, you have your fee contract. Then what are you supposed to do as the lawyer? Well, you surely better be competent in that area. If you're not competent, you better find somebody to assist you in it. I can tell you the reason I've done legal and medical malpractice work over the number of years that I have. It's extremely competitive. It's difficult. They fight tooth and nail. Try the cases are as long and as bitter as you can get, and I love them. They're just simply trial lawyers. If you're an active and participating lawyer, they're fun for me. That doesn't mean they're fun for the client, and you must be cognizant of the length of stress and hanging cloud over your client's head that's going to take place in these cases. So you must inform them up front what they're getting involved in. Normally I tell people it's 3 phases. Number 1, it's a learning phase. I don't know everything that's out there, so by discovery I'm going to do that. After the discovery phases and after your experts are in your hand, then you look at whether or not is there a settlement phase that's possible. It's a private mediation. Some courts mandate mediations. For example, Greene County up in Ohio cannot get a trial date unless you go through mediation, period. But irrespective, you look into settlement options. So if you have the time, I think it is a wonderful option to present your demand before filing suit. As we all know, the work triples once you file suit, and the amount of discovery and everything else that takes place. Your chances, just like in a personal injury action case for settlement, are much higher before you file suit than after, for lots of reasons that seem obvious. But number 1, if you are in a position to make a demand, you're prepared. If you're prepared, the defense knows that. So now it's just a matter of assuming you have your ducks in your line, you have liability established with expert opinions. Now it's just a matter of damages. Good friend of mine, defense attorney up in Milwaukee, always says, but every case is damages, damages, damages. So even if liability is at issue, if damages are high, you're going to be in a situation where you can sit down at a table and reasonably and prudently, hopefully, with the defense counsel, or vice versa, if you're a defense or plaintiff's counsel, try to work out a settlement in the case. I try to do that when time allows, by a demand letter that literally attaches every record that's applicable, attaches every document to support economic losses, attaches everything that is conceivable in the case within a case, because that's what a legal malpractice action is, and I'll get to that in a minute. But you give them all of the ammo because you're showing them you're ready. I'm competent in this area of law, is what I'm telling them. That means that I must have the prudent and reasonable efforts in legal malpractice law to know and navigate not just substantive issues, but procedural issues to prosecute an action on behalf of my client. So, having said that then, I have that duty. Very rarely is that duty denied in any pleadings. I don't know if I've ever seen it denied. Most every attorney admits they have a duty. Here's where sometimes they will not admit to, and that is if it goes out the scope of what they believe was the original representation. For example, if you learn something in the scope of your representation that is outside what you're learning, but is detrimental to your client, and or advantageous to your adversary, are you duty-bound to go ahead and inform the other side of those pitfalls? My opinion, absolutely. Now, was that your original scope of engagement? No. But in my opinion, put it in writing and then ask for a redirection on where we're going with this, given this newly discovered evidence, because it can and may make a difference in your case. So the third element, as you can see in the pleadings listen to me, the outline that I have here, is a breach of that duty, and that one's the hot button. Like I said before, commission, omissions, misfeasance, nonfeasance, I've heard it all. But what it really comes down to is somebody did something wrong. How? We'll go into some of the things on the second page of what we normally see are common errors. But the fact is that you did something no other prudent lawyer would do. Simply said. You didn't file discovery. And that discovery, if you would have done it, would have given you evidence to be able to prove your case. I see that a lot. You're not prepared for trial. You don't call an expert witness to trial. I've seen that, shockingly enough, where somebody has put on a case and they don't call an expert. The Supreme Court says you must have expert testimony testifying to the four elements that you see before you. And the biggest one is I usually get an admission in the pleadings to the first and second element, but the third one, and I usually will show that to a jury, by the way, real quickly, that has been admitted to. Defense counsel is getting smart. They usually admit to that up front as well. But irrespective, the third claim of breach is hotly